Of course, it starts recording right in the middle of a yawn. All right, so this is chapter 19, receiving and releasing information. So, one of the biggest responsibilities of our line of work is being very cautious about what information is given out, when it is given out. We follow HIPAA, which was discussed in chapter 2 in the PowerPoint. But we also, as substance abuse providers, also follow 42 CFR Part 2. Okay, that is a very, very important law to be familiar with. It's essentially what governs us. If you work at a really big agency that's dual diagnosis, so for example, High Point, Providence Center, South Bay, Star, it's 10:30 at night. You could have two separate individuals with two separate licenses treating the same client. One would be bound to HIPAA, one could be bound to 42 CFR. If you're primarily doing substance abuse treatment, 42 is applying to you. If you're just a mental health provider, and you're doing like depression, or if you're doing medical stuff, if you're a physician, then you're bound by HIPAA. So the laws can vary in that aspect, and they can become really muddy. So as substance abuse providers, 42 is for you. Okay, so blasting through this PowerPoint really quick. Sending information is really important, and it's important to have the proper releases. So releases of information has to be a form, has to be signed by a client, and usually those releases are good for about a year, typically, unless the client decides to void them out. You have to be able to put on there that the information on the release can be distributed to and can be received by you as well. Client has to be there. You have to explain it to them. You have to be able to identify why it's important. You also have to be able to explain what information is going to be on it and how much information is going to be distributed and when. All right. So going to slide 4 on this, most information is always given out during the assessment process, but releases can be changed or added or voided throughout any time that this person is in treatment. I apologize. So going to slide number 5 and just kind of blasting through this. Elements of a good release should always have the client's date of birth and their name on it, the purpose of it, so for progress notes, urine screen results, verification of treatment, psychosocial, medical, discharge after summons, whatever it may be. So that information should typically be on it. There should be 2 signatures, a client and the person witnessing it, which should be you most often, and always, always, always have the date. The date is one of the most important things because that's essentially what makes it valid. If there's no date on it, then who knows when that release was actually completed, especially if someone has been in services multiple times. Now, for our releases, your release for substance abuse treatment has to have on there in the bottom, you know, there's always that section to fine print. It has to say 42 CFR Part 2 in it. Sometimes it's mentioned multiple times. If 42 CFR Part 2 is not referenced in the release, you cannot distribute any substance abuse information. That is it. I have received releases from probation, from DCF, from parole, requesting information, and 42 CFR is not cited in it. I don't send anything out. I don't even need to send it to our medical records department to get their input on it. It's not there. I'm not sending it out. I've gotten requests from court investigators investigating a court situation involving children. Does not matter. Unless it's signed by a judge, I do not send it out. I've even received, what was it? It was the document that the lawyer who's a court investigator signed. It's like the contract for the investigator, because basically a lawyer is the one that says, yeah, I want to be an investigator, and agrees to investigate a particular case. Oh, sorry, I can't keep recording this. Well, that's like what I was sent one day. And I'm like, this tells me nothing. This tells me that, yeah, that they're in the investigator, but it doesn't give me permission to send this information out. Some things are going to be real black and white where you look at it and like, this is like wicked generic. It's not even on the letterhead. Like this person totally just typed this thing out and had a client sign out. Absolutely not. And then there are others where you go, I'm not so sure. And that's when you want to consult with people and get their feedback on it and ask them, would you distribute this information? Now, it's important to know that the only time, and I mentioned this in the key terms, the only time you can give out any information without a client's permission is if they're a threat or danger to themselves or someone else. That includes driving under the influence, which is probably the most common reason why we would relate the information. If you are talking on the phone with them and they don't sound good, if they're sounding suicidal, or if they potentially hurt themselves or just put themselves in a hazardous situation, then and you need to call like 911. That would be another reason why. If a child, elderly, or disabled person is being abused, neglected, or exploited. So if you found out that you had a client who is actively drinking or using and caring for their children, if you're questioning their ability to parent that children safely, and especially if they're high risk for things like overdose, suicide, no, that's when you would call the hotline and report it and then let the investigators deal with it. It's always best to report it and let them be mad at you for reporting it than not reporting it at all and something bad happening and then you being responsible for that, because you have a duty to warn, you have a duty to inform, and a duty to protect. If you find out that there's people in the home that's taking advantage of an elderly person, especially if they're not well, if you're concerned for their well-being, if you are seeing bruises on people and they're minimizing the situation, you can definitely report that too. You can report the elder services, or for substance abuse, excuse me, I'm dehydrated. For substance abuse, you can actually refer to the Department of Disabilities. So they kind of function the same way that that like DCF and like the elder services, like you have a report, you report it, and then they send someone out and they investigate it, and sometimes they can help press charges if need be. If they commit a crime on the premises, so if someone gets mad at me and they slash my tires on my car, I'm calling the cops, I'm ratting them out, I don't care. If a drug deal is taking place on the premises, you can definitely report that, and you can report that to the police. If you're doing any of that kind of reporting, you give minimal information. You can say, hey, this person is committing this offense, or I saw this commission of a crime by this person over here. You don't have to say to what capacity that you work at, or that you know this person or anything. Like, you can keep it minimal, but you're committing a crime, you do the time. Lame. So sorry, it's literally 10:46. Then the other one is if there's an actual court order that is signed off by a judge. Now, the interesting thing with that is if it's a court investigator. So let's say you have a family member, two exes, and they're fighting for custody of the kid, and they're in probate court. And one person is alleging that the other person does something naughty, and the other person does the same thing. Well, if there's a lot of questions, the judge for the court can appoint a court investigator to investigate the allegations or the suspicions or whatever it may be. And that's typically an attorney or sometimes a guardian ad litem. So what happens there is I get a court order signed by the judge, and I can give it whatever information that court investigator asks. Sometimes they are very thorough and they ask a lot of specific questions, and I give them everything. Sometimes they barely ask anything. I only give them what they ask. I'm not going to tell them anything that I don't feel like they need to know. And if they're not asking for anything particular, I'm not telling them. If I have some pretty legitimate concerns about this particular client, and if I feel like child safety is at risk, then obviously you do your due diligence and you distribute that information as necessary. But really what it comes down to is that if a client is in treatment and they're doing relatively well, and someone calls for information and they don't ask for questions or need that type of specific, then you don't say anything. Okay, so those are the circumstances in which you would give information, and that is something you have to tell the client. I don't care if they've been there 80 times or for 8 minutes. You have to say the same thing over and over and over again. You're protected by HIPAA, also 42 CFR Part 2. I can only give out information in the event of I have a release. I can only give out information, and like you go through it. It should be very, very automatic to you, just like a song. You have to say it. You have to make sure that they know it. And the more consistent you are, if anything were to happen and you were deposed or brought to court and someone said, do you explain 42 CFR Part 2? You should be able to say with 100% certainty and confidence, yes, with every client, I explain the releases of information. I explain 42 CFR Part 2. You should be able to do that. Not, well, for some I do, but for some I don't. Can't do that your credibility is out the window. Okay, so releases are absolutely important. You have to explain it, you have to be thorough, and you have to be able to keep up with those types of releases. If you're meeting with someone for over a year, you need new releases to distribute any information because it's expired. So that's the other thing to keep in mind as well. Okay, so get your releases, don't distribute anything. If anyone calls asking for any information on a client, your response should always be, I cannot confirm or deny anything. Sometimes family members would call and you can say, I can't confirm or deny anything, but is there something you'd like to tell me? And they'll go la 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 la. And you say, okay, I can't confirm or deny anything, but if this is useful, thank you very much, and just kind of move it along. And then of course call the client and let them know what's going on. Now, if it's a family member who's an emergency contact and you're acting in good faith and can share that, then yeah, absolutely. And I've had to do that before where I was really concerned for a client and they had a history of overdosing and had some recent overdoses and they weren't responding to my calls. Sometimes you have to call a family member and say, hey, listen, I'm really concerned about this person. They're not responding to my calls. I'm worried for their well-being. And, sometimes they can get mad, but you know what? I'm coming from a place of care and concern for their well-being and the well-being of others. And, that's just what we do. That's how we have to intervene.